Thank you so much for joining us today. Today, our webinar series is going to be a very important one. I'm sure it concerns a lot of our boards, and that is how to navigate quality of life issues as a board. That is something that plagues, whether you're a resident or a broker or a board member. So this is a really interesting topic. So joining us today, we have a wonderful professional colleague, Stephen Lasser, who's a managing partner at the Lasser Law Group. Thank you for joining us, Stephen. Hanley Braginsky, who's a senior vice president of management here at AKAM. And then myself, hi everyone, I'm Elise Rosemarin, and I am also a senior vice president here at AKAM. Thank you for joining us. So I know we are doing a lunch and learn style, so we'll try to keep it brief and keep you informed. We invite you to ask questions as we go through our topics, and we will be circulating and recording this webinar. So should you want to go back or we're missing this today and you want to refer to it, we will keep this also on our website. So today we're talking about illegal sublets and short-term rentals, illegal alterations, unit responsibility, who repairs what, why homeowners insurance matters, excessive noise and odors, never hear that complaint, disability discrimination, support and service animals, what boards can and cannot do, reasonable accommodations versus modifications, risk management, and best practices for boards. And then we'll do a Q&A. But I always invite people to do, please please put any of your questions in the Q&A box, and we will refer to it as we discuss. All right, so Stephen, you want to get this party started?
Sure. So thanks everyone for taking time out of their busy days to watch this, and thank you to AKAM for inviting me to be a panelist. And I'll get right down into it. Just a little bit of background about myself. My firm represents about 220 co-ops and condos in New York City and Westchester and some of the other surrounding counties. And some of these topics, could be a 2-hour discussion. Since we're time limited, I'm going to try to just sort of give you some nuggets, maybe cover some things that you don't already know. You're probably familiar with these issues. So trying to add some value here. So illegal sublets and short-term rentals, basically those are both, categories of illegal rentals, but I think it's easy to sort of differentiate the two. In a co-op, there's usually restrictions on rentals, right? You need board consent. Whereas in a condo, it's usually just a right of first refusal. So it's a given that you can rent, but usually there's restrictions on rentals for less than 30 days in a condo. In a co-op, you could, in theory, evict someone if they violate their lease and illegally sublet. And in a condo, you're more limited. You'd have to get a court order, an injunctive relief, that's called, or potentially, fine the person. So this is the long-term illegal sublets is more of a co-op issue. And the interesting thing is that the in co-ops, oftentimes you'll have someone say that they're a roommate, and there's a roommate law. And basically in a co-op, if you have, for each adult occupant on the lease, they're entitled to have an adult roommate. So that's all, frequently a source of controversy. Someone co-op board thinks that there's a illegal rental. They say it's their roommate, and then you have to maybe potentially hire an investigator, put in security cameras, or do some more due diligence to see if they're actually living there concurrently. And then just another sort of interesting point there is that the appellate courts in New York City have different views on the typical language in a proprietary lease. Most proprietary leases say that the apartment must be occupied by the shareholder, and it can be occupied by the shareholder and their family members. And in Manhattan and Queens, the appellate court covering Manhattan and Queens, the courts have said that and means or, meaning, excuse me, I said that backwards. And equals and, meaning that in Manhattan or Queens, the shareholder actually has to be there with their family members, or be considered an illegal sublet. In Brooklyn and excuse me, that was in Manhattan and the Bronx. In Brooklyn and Queens, if you don't have to concurrently occupy the shareholder does not have to concurrently occupy the apartment with a family member. And this case law sort of changes over time. So if you're in a co-op and you're gonna sort of try to crack down on a sublet and you're going to go to court over it, just make sure that you're up to date on what the current law is, whether they're a roommate and whether they're a family member, because that could impact the outcome of the case.
Stephen, real quick, what defines a roommate versus a subtenant?
Well, I think one issue is whether the two issues I think really are whether they're concurrently occupying the space. So if the shareholder or unit owner is not there, I think it would be considered sublet. Also, if there's money being exchanged, I think that's an indication that it's not necessarily, or more of an indication that it would be a sublet, versus a roommate situation. Although a roommate could contribute to rent, so it's one of those gray areas. That's why it's hard to litigate those cases. They can be tough if someone wants to claim that they're having a roommate. And that was intended to protect, I think, rent stabilized tenants. It wasn't really designed for co-ops, but it applies to co-ops as well. The short-term rentals, are usually through Airbnb, and that issue affects condos, I'd say, and co-ops equally. I think in recent years there's been a decline in those, and I'll explain that, the reasoning why in a second. But short-term rentals can be dangerous because you have transient people coming in and out. They don't care about the building. There's more chance of theft, and then also the hotel lobbyists have sort of really pushed against short-term rentals because they claim it's a safety issue. And there's some truth to that. Co-op, excuse me, if you're in a multiple dwelling, it's not the same as a hotel. The safety requirements, the fire safety requirements aren't as stringent. People might not know where the safety exits are and things of that nature. In any event, the state has and the city have actually passed a lot of laws to sort of crack down on Airbnb and short-term rentals. So there's a law that was passed, I think, in 2010. That's multiple dwelling law, 4.8, and that bans any short-term rentals in a multiple dwelling for 30 days or less. So, right out of the gate, short-term rentals are illegal in New York, period. All right. Then in 2016, the state passed multiple dwelling law 121, which bans people from advertising short-term rentals. Now, that didn't really stop people from doing it. So most recently, in 2023, New York City passed a law requiring anyone using Airbnb to register with the city, and Airbnb and other sort of home sharing apps will a not accept a rental from an owner unless they register with the city first. So basically, Airbnb verifies with the city. And then another added layer of protection is that you can now register, a building can register. There's a portal in New York City. You can register and put your building on a prohibited building list. Prohibited building list. When Airbnb looks up to see whether they can allow an owner to rent their apartment, if your building is registered, Airbnb will not allow them to list the apartment. So there's a lot of sort of legislative measures that have been taken that have made it much more difficult to make a short-term rental, particularly in the city. People still do it, and they use other platforms. People, I think, will always do it, but I think there's been a decline in that. I don't know, Hanley, I don't know if you want to chime in on that, what your experience has been with illegal sublets, or with, if you still see short-term rentals as a problem.
A bit of experience, in fact, and what you touched upon earlier is there has been a decline over the years. I think about 10 plus years ago, when Airbnb was just a common theme in most properties, that has declined. A lot of the efforts were as a result of co-op boards and condo boards sort of playing a more active role in identifying policies and procedures, which makes it a bit more challenging for folks like this to have these sort of practices. So instituting fines, having guest login forms and information. So anybody that shows up to a building has to identify themselves, leave a driver's license, ensuring that staff remains diligent about that. In some instances, staff members are rewarded for anybody that they conclude is indeed an illegal subtenant, whether it's through Airbnb or other means. So all these efforts have technically made it more and more challenging for anybody who's even contemplating doing something like this in New York City. That said, you still have to keep a watchful eye even today, because something could always slip through the cracks. So what I always recommend to boards is look at your guest policies, review them annually, even see how you can improve them. But the eyes and ears of the staff is arguably the most important, but also notifying residents on a fairly regular basis that these practices are prohibited, and if they see any suspicious activity, to report them to management so that management can take immediate and swift action.
Thanks, Hanley. We have received 2 questions, if I could ask. So can condos regulate and require advance notification to boards on existing rental renewals and impose a fine if the owner fails to do so?
No, I'll try to answer that. I think with condos, you generally have to look to your bylaws for whether there are restrictions on sales and leasing. And usually there's a section in the bylaws that pertain to sales and leasing, and it might not be that detailed. Typically, it's not. And what I always say is, I suggest to my clients that they be more aggressive. I think even though it technically should probably be an amendment of the bylaws, that would require a supermajority vote of the unit owners. So for things like that, I would say that the board should just put the policy in, implement the fines, and if someone's a rule breaker, they'll complain about it anyway, and they're not going to comply. But maybe you'll get someone to comply that might not otherwise when you start fining them. So I think it would be a good idea for the board to implement such policy, even though it's in a gray area potentially.
And then the second question is regarding the concurrent occupancy provision of a co-op lease. Does that mean in Manhattan that the shareholder must be present physically when a roommate or guest is in the unit? Or if the shareholder uses the unit as a principal residence, is that within the lease for a guest or a roommate to occupy the unit on days when the shareholder is not present?
Well, that's an interesting question, and I think it's pretty nuanced. I think that if the shareholder can prove that it's their primary residence, in other words, that they're there, more than 180 days out of the year, then I think that the person would probably be considered a roommate rather than a sublet potentially. So,
Thank you. All
sure.
right. So I think we don't have any questions further on that. So can we move on to illegal alterations? I guess, Stephen?
Sure. So, illegal alterations in every building, co-op or condo, there's going to be alterations, and the way to sort of prevent illegal alterations is to require an alteration agreement, right, and get the board's consent. That's pretty typical in every building, where the devil is in the details. So, in a co-op, the board must consent to alterations, and typically the language provides that it can't be unreasonably withheld. In a condo, you can also usually requires board consent, but a lot of times it's nuanced and it's only for structural alterations. But in any event, the way to sort of enforce illegal or prevent illegal alterations is to make the policies known, and to have vigilant building staff to see if there's something going on, that either alteration wasn't approved, or if it's something beyond the scope of what was originally submitted. And then you can also have inspections during the course of the construction, to sort of police illegal alterations. And I'll just add that in any event, in a condo, even if the consent is only required for structural alterations, along the lines of what I said before, I'm usually suggest a more aggressive approach. And even if it's not a structural alteration, have the alteration agreement in place and let the person push back. Just be aware that if if you have that structural language and it's not a structural alteration, then you would lose if you litigated that. But more often than not, people are going to comply. I think most owners want to comply with rules, and they see the value of having alteration agreement in place, and it protects their neighbors, it protects the building, protects them. And the other thing I would just add is, even if, let's just say that an alteration agreement is not required by your condo bylaws, they typically always require indemnification, and that that would also apply to it in a co-op. So you want to get your contract, you want to get and have indemnification language in the alteration agreement, indemnification from the shareholder or unit owner. You also want to have a separate indemnification agreement signed by the contractor. And the reason for that is, when you obtain certificates of insurance, it might name you as the building and the board as an additional management as additional insured. However, there's a lot of policy exclusions in the way a lot of the insurance policies are written, particularly for contractors, that it says that unless you have a contract naming, indemnifying you, then the fact that you're listed as an additional insured doesn't matter. So it's a really important issue, and I believe that it's pretty widely known. There's lots of articles and things about that, but just something the board should be aware of, that you want to get the contractor performing the work to sign indemnification agreement. Someone violates their alteration agreement, or they're doing something beyond the scope of what they're supposed to be doing, you can get a stop work order from the city. You can also fine them, and in a co-op, in theory, you could evict someone from their apartment if they violated the alteration agreement, which would be a violation of lease. And I'll just throw in there another actually important point is that there's usually a no wet over dry provision, and that we're going to talk about leaks, I think, in a couple of moments. But that means that you can't sort of put let's say a bathroom over someone's bedroom. The way most buildings are designed, there's particular apartment lines, and the plumbing fixtures are lined up. So that way, if there's a leak in someone's bathroom, it's just going to go to the other person's bathroom. I don't know if, Hanley, if you want to add anything about whatever dry, or just general alteration considerations.
You're on mute.
There we go.
I'm sorry, it was loud in this room. Can you just repeat your question, Stephen?
No, I was just saying that if you had any thoughts on no wet over dry, or if there are other sort of policies that
Yeah.
boards implement that are like typical in an alteration agreement or during construction.
Absolutely. Yeah. So wet over dry, I think, is 99.9% policy or a violation of the agreement, and comes up often in any third-party architectural reviews. They're not necessarily a code issue, but they're generally a matter of policy, and something that most boards tend to not approve. There's certain sort of liberties that can be extended depending on how far the wet section is over a dry section. So for example, if somebody's expanding their footprint of their bathroom by a couple feet and it's going over a closet, that area is going to be waterproofed. In fact, it's going to provide more protection than the existing situation. Because remember, if something leaks, water doesn't decide just to stay in the footprint of the bathroom. It's going to go wherever it needs to go. So there are some, liberties that can be considered, but there are other things. If you're living in a landmark building, you may want to look at your alteration agreement and what is permissible. And often what comes up in landmark buildings is when residents look to replace windows. You can't just replace with what you want or what has the best rating for soundproof or UV. You have to meet what the Landmark Preservation Commission would require. What I would say to boards, or any board member who's on this right now, which I think is everybody's a board member, is that if you haven't looked at your alteration agreement in the last 5 years or more, it's probably a good idea to revisit it again. Do it in conjunction with your building's architect, have them go through, and they'll probably understand and know what your building is dealing with. I think the most important thing is that you want to prevent or avoid any adverse impact to the infrastructure of the building, your neighbors. You don't want to start introducing anything. While it may increase the value to that particular individual's apartment, you don't want to introduce something that may bog down the infrastructure, the plumbing, the electrical, etc. And your architect would probably be in the best position to advise you. Once you do those, take those recommendations into consideration, and then you say that, this makes sense for our building, then have your co-op attorney, co-op condo attorney review it, make sure that legally everything is airtight. So that's the steps that I advise many of my boards who are looking to beef up, so to speak, their alteration policies.
So what about allowing the super to perform an alteration under the cooperative's insurance? What are your thoughts on that?
Is that for me or Stephen?
I would say Stephen.
Okay.
Protect you legally, Hanley.
Okay.
I think generally it's not a great idea. I think that you're going to run into an issue as to whether who they're acting for and whether it's within the scope of their employment. And the reason that can be critical is if a super gets injured performing an apartment repair and it's for the benefit of the shareholder and not something that's the building's responsibility. In theory, if there's an accident, it might not be covered by workers' compensation insurance. So I think that's an area you have to be pretty careful with. Although I think a lot of supers do repairs in apartments, and on some level there's a value add there. I just think you have to be careful with that for sure.
Similar question: can a board recommend building staff to owners to repair certain projects, but leave the building staff to contract directly with the owner? And how can the board protect itself from liability?
Yeah, I think in those situations, if the building staff is doing work, I think that you're probably better off having it as part of their employment, and then it gets billed back through the co-op or the condo building, so that it's actually work that they're performing on behalf of the building in theory, but they're getting reimbursed. In other words, the unit owner would pay the building, and it'd be like a pass through. I think that's like the safer way to do it, where you avoid the situation of if the person gets injured and who are they working for? Are they insured? I don't know if you have any thoughts on that, Hanley, or how you guys deal with that.
Yeah. As a general rule, I sort of discourage building staff to perform private work. I feel that it kind of opens up a lot more problems than benefits that it creates. While yes, you may have a skilled individual on your staff and he'll probably charge you a few bucks less. What I tell boards is, if you're with desire to have a staff member or multiple staff members do that kind of service on a regular basis, you go one of two routes, which some buildings do. They have sort of a menu of services, sort of to what Elise sort of alluded to, is say, these are the 10 or 20 things that the staff will do. This is what the cost is. Then you ensure that the cost is consistent. One neighbor isn't being charged more than another neighbor, and everybody understands what they're responsible for and accountable for. But anything separate from that, I would say where what gives me a higher level of comfort is if that staff member wants to go out and get their own insurance certificate and be treated like any other vendor, that they can certainly perform work in your community just like any other vendor. The challenge that I get into is most buildings have building rules as far as when work can proceed, Monday through Friday, 9 to 5. So if that staff member is already working as your doorman, your porter, your concierge, your handyman, when are they going to do that work? So if you're going to start making exceptions for certain jobs, let's say it's quiet work, paint only on weekends, to allow that staff member to do it, then just recognize that you're going to get pushback from other residents who may have their preferred vendor who are going to expect the same. So that's why I try to avoid it. But if there's a really, really good reason, then, you could certainly institute that. But again, it all comes down to what parameters you're setting, and try to make it as consistent as possible.
So similarly, is the co-op protected by its own insurance if a handyman gets injured doing private work for a shareholder? An example they gave was washing windows.
Hopefully, if they're washing the windows, it's on the inside, not on the outside, because I think you need a special license for that, and that's obviously a dangerous thing to be doing. But again, I think it's gonna, you know, it's a question of fact, and you know, I couldn't say with certainty if, you know, it depends, you know, what time of day it is, you know, whether they were authorized, whether the co-op, you know, said, you know, knew you know, management was aware or the super was aware that this person was doing, you know, work during, you know, on behalf of a shareholder, and you know, if it's during business hours or after business hours. So, I don't know if the question was, could the co-op be liable? I think the
Yeah.
answer is potentially yes. So I think that's, you know, to Hanley's point, it's probably not a great idea to have um, building staff, you know, working privately for owners unless there's some, you know, very clear guidelines as to what has to be followed, and you have all the, you know, the proper protections in place.
Understood. Thank you. Well, this comes up a lot. Who repairs what? I think you were speaking to leaks earlier. So, you know, an owner is usually responsible for what versus the board or the building.
Right. So typically um, the the walls and the sort of the shell of the unit or apartment is the building's responsibility. And I'm talking like specifically, you know, more often in the context of you know, leaks, but that's also generally the infrastructure is the building's responsibility, and then the interior and all the interior fixtures and upgrades, decorations, things of that nature would be the owners or shareholders' responsibility. And the, you know, when you look at like a co-op lease or a condo's bylaws, they usually have sort of the general repair and maintenance paragraphs, and then they also have a casualty paragraph. And when you're dealing with leaks, you're gonna be under the casualty paragraph. So normally, even if let's say, you know, the building is responsible for, you know, fixing the wall, um, if there's if it was damaged, let's say by a leak, you're going to look at the casualty provisions, and basically, you should each person should file a claim, or each entity should file a claim with their own carrier. So, for example, if there's a leak from one apartment to another apartment, let's say an interior leak, you know, within the walls, then the person that downstairs that's damaged should put a claim through their carrier. The person that's upstairs should put a claim through their carrier, and the condo or co-op could put a claim through their carrier, and the insurance companies will sort out who's going to pay for what. You know, there might be mitigating factor if there's negligence, but the idea is that the purpose of insurance is to cover everyone, and you don't want to have someone that's not insured, or you don't want someone that's not insured or someone that's underinsured. So the insurance becomes very important in you know, casualty situations, because you know, floods can cause a lot of damage, or you know, fires, things of that nature, can really be significant in the amount of monetary damages that could be incurred. And
A few questions.
sure.
Relating to the repair of walls, would mold remediation be included?
So mold, I think, is, you know, it depends, but the mold usually takes time to develop. So I think a lot of insurance companies will say, well, hey, this has been an ongoing problem. It didn't just happen overnight, and therefore, you know, and we don't know if this was a pre-existing condition because you didn't tell us, you know, when there was a specific like uh, leak that occurred. So a lot of times, you know, insurance carriers, whether it's for the building's carrier or the individual's carrier, are going to disclaim um, mold remediation. Although I've seen it covered before, and I think that it ties into another important point, in that it's very important to notify your insurance carrier when there is a claim. You don't want to wait on that, because if the carrier is prejudiced due to the delay, like for example, if they say like the mold, you know, it looks like it's been here for 6 months, we're not going to be responsible for that. They might get a pass on providing coverage. In recent years, the courts have have sort of pushed back on carriers, but I think in a lot of instances, not to disparage insurance carriers, but their default is we're not going to provide coverage. So you don't want to give them any extra support in that regard, and you want to promptly file any claims that you have.
What if the bylaws say no subrogation?
Right. So typically, if subrogation is that the carriers or the party that's damaged can go after the other party, and most bylaws, I think, have a waiver of subrogation, and that goes back to the point that everyone files a claim through their own carrier, and the carriers won't go after their other carriers or the individuals. They'll just they're going to take on the responsibility for whatever it is that they're responsible for under their policy. So that's pretty standard
And
that they'll
then,
go for subrogation.
what if all parties put in the claim, for the example, upstairs, downstairs, in the co-op? Isn't there a danger that they'll all be denied coverage, and how do you prevent that?
Yeah, there's definitely a danger of that occurring. I think if you're looking at it from the board's perspective, I think you tell the owner that they need to put in the claim under their own carrier, and give you that response before if the condo or co-op thinks that it should be covered by the owner's carrier. Let the owner file first, and tell them that you're not gonna that we have to see if there's coverage available before we put it through with the building's carrier. And I've seen that work out successfully. Um, so if there's three insurers or two insurers involved, someone's got to be responsible typically, unless it's something that like I said, mold or something like that. That was sitting for a long time. Otherwise, there should be coverage. You just got to sometimes play a little bit of hardball with the carriers, but they'll come around. I've definitely seen a lot of changes in coverage opinions in the course of my career.
For sure. This could be a Hanley or you, Stephen, question. In the who repairs what scenario, assume a leak in branch piping that runs from a riser and provides service to a unit's kitchen or bathroom, or a drain from a unit tub or a sink to the common drain. Does the standard co-op lease impose responsibility for the branch pipe leak on the shareholder? What if the branch piping was installed as part of a shareholder renovation of the unit's kitchen or bathroom?
Well, that's your answer, right? To keep it in simple terms, if you touch it, you own it, right? So if it was an original branch pipe, original to the building, never touched, and it were to leak, or regardless of where, the co-op would go in and replace it in the same manner that they would replace a riser, right? But if this was part of a renovation, which most renovations, and again, going briefly back to the alteration comment, that's one requirement that most co-op condo alteration agreements have, is when you have exposed plumbing, you replace the branch lines, the lateral lines, and the shutoff valves. So if that happened and a year or so later, those were to leak because of shabby workmanship by some plumber, that would be the shareholder and or unit owner's responsibility. That's why you collect insurance certificates and you pursue that vendor for those damages.
Got it. And then does one put in a claim regardless of the level of damage, does that affect the policy deductibles?
Well, we should really have Brian Boak on this call for
Yeah.
that. He's our insurance expert. You know, we as managers have been trained for a long time that you report claims, any incident for info only, because you never know if that little leak can rise to the magnitude of now mold and this and that or the other, where people are now claiming health issues or whatever. And, reporting an incident late could disclaim your coverage. Now, some properties, because of rising costs and premiums, have a different practice that I've seen where they say, look, depending on the magnitude of the issue, if it was resolved swiftly with limited damage and it's well below our deductible, we're going to go ahead and handle it and leave it at that. But that I would encourage a discussion to be had with your insurance agent, your risk management person, and see what really makes sense for you.
Got it.
I was actually, I believed for a period of time that unless the carrier paid out on a claim that it wouldn't affect your premiums, but I was corrected by an insurance professional, and they said that, even though you have, I think it's called a loss run, they'll still look at how many claims you submitted, even if
Right.
you didn't pay on them. So that could adversely affect, your premium. So, to Hanley's point, I think you got to look on a case by case basis. And although it's probably safer to submit the claim, it could affect your premium. So you have to sort of make a business decision as a board.
Thank
Correct.
All right, you never hear this. Noise and odors, excessive noise and odors. What do we do about this? What are some resolution tools?
Sure. So, the city has for noise complaints, you can call 311, DEP, and the New York Police Department can come out to handle noise complaints. And a lot of the typical ones are loud music, kids playing, right? And then on the odor front, um, marijuana, especially now that it's been legalized, and then just smoking in general, and then cooking smells are things that sort of, I think, are quality of life issues that affect most buildings at some point in time. And you can call the government agencies, or you can sort of try to resolve things yourselves. And I always say that the first step is to try to potentially mediate an issue. You might have a situation where someone is practicing their instrument during certain hours. We actually have a kind of a crazy case where someone is probably going to be evicted. They're apparently a very renowned pianist, but they play like during hours that they shouldn't be playing, and it's been ongoing litigation, and there's actually a warrant of eviction issued because this person continued to play their piano, even if it was good playing. It was during hours that it was prohibited, and the court agreed with the co-op that this behavior couldn't continue and this person couldn't control themselves. But anyway, you have the legal remedies, but what I'd say before you get to that, you want to try to mediate things. So if you can get the people to agree, maybe they're only going to smoke, if you're a building that permits smoking, they're only going to smoke on their terrace during certain hours. The other people aren't on their deck or terrace or eating dinner or things of that nature. So um, I think mediation is the way to go if you can do that. Same thing like if you have a pet that's making noise. And we're talk about pets more in a minute or two, but same thing. Like if you can try to get the people to collaboratively come up with a solution, get the manager involved, to get your attorney involved, to try to come up with a way to um, get the parties to sort of police themselves, so you don't have to take them to court. That's the way to do it. There are soundproofing experts, acoustic engineers, I think, and there's also, we had a situation with a Michelin star restaurant that had a wood burning stove that caused a tremendous odor, and we ended up having to sue them. Unfortunately, we hired a industrial hygienist, and they were able to recommend a ventilation system, and then sort of everyone the restaurant put in the ventilation system, and the odors went away. So there's usually a creative solution if you just put your heads together. Try to get
We
them
were speaking
resolved.
about pets earlier. So what is, disability discrimination and some common violations?
So with the discrimination laws, there's city ones, state, and the federal ones, right? For the federal one is ADA and FHA, and if you have a disability, you're entitled to a reasonable accommodation, and the key word there is reasonable. But the agencies that police these infractions, their perception of reasonable is pretty broad. And so I think the two big issues that come up in co-ops and condos are emotional support animals and accommodations in common areas such as ramps or lifts. And if someone has a disability and they have medical proof of that, they get someone to write a medical professional to write that they have a disability, then the boards have to engage in what's called the interactive process. You have to um, respond to their inquiries and show that you're taking steps to address them. And basically, with respect to a request for emotional support animal, if someone has a disability and they have a doctor's note saying that their pet will help them with their disability and using their apartment, then you're not really going to be able to do much with that, you're going to have to provide a reasonable accommodation, or you can, run into all kinds of fines and penalties. And sort of similarly with, let's say, like a ramp or something at your entrance, it has to be reasonable. I think, Hanley, you had told me previously that you had a situation where they said it was that they would have to redo the whole building or something like that in order to
Yeah, it was a situation last year where it wasn't even a resident of the building. It was a patient of a doctor who has a professional space in the building, and it was an issue regarding a staircase, and didn't necessarily accommodate somebody who was wheelchair bound, let's say, or made it challenging. We do have like a portable ramp that we can install, but it wasn't adequate for this person. And what I could say is, in dealing with this individual, it was clear that they were trying to build a case towards something. Now, thankfully, it went nowhere. But under the advice of counsel at the time and others, we had to take this seriously. Couldn't dismiss it just because it wasn't a resident, and we had to look into if there was any feasible measures that could actually be done to implement some kind of accommodation. What it turned out is, aside from tearing down the building and rebuilding it from scratch, there really wasn't any. So that, put it to bed at that point. But I think the lesson to be learned from here is, when these requests come in, is not to push them off, but to really treat them as, as if it was anybody living in the building who needed that. And if there's something that can be done, unfortunately, even if it costs a few bucks, it sounds like, the law compels you to do something about it.
Yeah, 100% on that. It would require you to, but I think that the key to your point is that if you engage in a dialogue, that there's a legal term, they call it the interactive process. As long as you're engaged in the interactive process as a board, you're not going to be liable. Even if there's a delay in getting the work done, but you can't just ignore someone. And then sort of along the lines of with emotional support animals, that doesn't mean that someone could have a pet that disturbs other people. The basic rules still apply, with respect to noise, and sort of maintaining your dog in a manner that doesn't affect your neighbors. But you can't charge if it's a building that has a no dog policy. You can't charge like a fee for having a dog and things like that. Like they need to be sort of treated equally, and that's sort of the overarching principle behind these disability laws, is that someone with a disability should be able to enjoy their apartment like everyone else. So whether that means they need a dog to do that or they need a ramp to do that, if it's reasonable, then you have to make the accommodation.
Understood. We have a question regarding noise. If two shareholders in a co-op keep arguing in the gym about noise and talking, should the board become involved in stopping this, or not get involved in shareholder disputes? I guess Hanley or Stephen. What are your recommendations?
Can you repeat the question?
Sure.
I'm sorry.
It seems that two shareholders in a co-op are arguing in the gym, and they're arguing about noise and talking. Should the board get involved in stopping this, or should they just leave themselves out? And shareholder
The board
disputes
should,
in general.
yeah, I mean, the board should really try to leave themselves out as much as possible. That's why you have a management company. That's why you have lawyers, right? Before you go to a lawyer and spend money, engage your managing agent, see if they can diffuse that situation, perhaps mediate their differences, what have you. If it needs to escalate, then you always have the ability to go towards legal avenues. On certain occasions, maybe the board member has a relationship with one of the residents and can just have a very frank, neighborly conversation with them and can settle it. But I'm very much about process and following that. And unfortunately, I've had to deal with similar sort of disputes in the past, and that's how I've dealt with it. I think a lot of times, most rational folks, they'll hear from the managing agent. The managing agent explains to them what the rules are, and treating your neighbors fairly and what have you. And that most of the time it goes away. But the managing agent will report to the board, inform them what steps are being taken, and from there, we can try to resolve it as best as we can. but it puts the board in a very difficult position if they have to play favorites, and that's something we encourage them to avoid as much as possible.
Sure. We have two similar questions regarding noise. One of them actually went to court and invoked an 80% carpeting rule. But how do you really make that invoked? And if there's constant complaining about noise from a shareholder about a resident above them, what are some suggestions that you have to make sure that these remedies are imposed?
So I think that if you have a situation like that, that the board or management should investigate the issue, and you could also the shareholder that's being affected could record the noise. I think the problem with noise claims is that they're not always constant, unless it's like an air conditioner. But if it's someone stomping loudly on when they walk, slamming doors, it's hard to determine whether the person is being oversensitive, the person that's being adversely affected is being oversensitive, or if it's a legitimate concern. And then the noise codes in the city at least are pretty liberal, I'd say, in the amount of noise that you can create, and the duration before it violates the codes. So they're tough situations. I think mediation is the way to go. Try to get the parties, maybe they're doing something at a particular hour, try to intervene and get the people to modify their behavior. But push comes to shove, I think from a board's perspective, you'd like the shareholders to work it out themselves and let the shareholder who's affected potentially file their own lawsuit. But if it rises to the level where it's a breach of the warranty habitability, particularly in a co-op or also in a condo, if it's so loud that the person can't live there, then I think the board does have an obligation to intervene. But can be difficult to prove, and I think it's a case by case basis.
Would habitability be also inclusive of if someone is a hoarder and they have vermin? Would that be a consideration to also have included in their noise complaint?
Oh, for sure. We deal, unfortunately, we've dealt with quite a few hoarding situations where it's a fire hazard. And added to that, we've had not only are they hoarding, but they have bed bugs, and we've had to take people to court for that. But it's a pretty common issue, and it's one that the board should address because it could adversely affect the safety of the other residents of the building.
Yeah. So as we end this presentation, which has been really informative, and thank you. I know a lot of our boards will probably have follow-up questions. If we can just go right back real quick, just as a way to mitigate your risk and best practices, can you each maybe provide a little summary of what you recommend?
So for alteration agreements, I think it's important that you have one in place, that you have the proper insurance indemnification provisions in those alteration agreements, and that now, thanks to Adobe, we can scan the alterations. I think in the past, the alteration agreements, there'd be a paper file, and you wouldn't always know what was done by the previous owner. So I think now the best practice is to save everything electronically. And just monitor the alterations as they're going, but make sure you maintain those records for the future, so that sort of prevents disputes down the road as to who's responsible for what. So that's one recommendation there. Sublet approvals. I mean, in a co-op, it's subject to the board's consent. So it's up to the board. I think there's a whole list of issues. If you're on a co-op board, you're probably aware that that there's certain things that you can't ask, and there's discrimination laws, so you just have to follow your policies. But basically, co-ops have broad latitude to reject sublets. In a condo, it's typically the right of first refusal.
Yeah. We have two questions real quick, if you wouldn't mind. One is regarding the repair, and Hanley, I think this is for you. Return to the hypothetical of the branch pipe leak and assume it is original to the building. If the building then has the obligation to repair and does so, when the pipe wears out, is the building still obligated? Is there any incentive for the shareholder to take on responsibility to repair or upgrade branch piping?
I mean, I don't know that there's any upgraded branch piping that exists. So, whatever you're going to buy from a plumbing standpoint is there's not like, the Honda version versus the Mercedes-Benz version, right? As long as the building continues to maintain it, the building will continue to be responsible for it. But with all that said, and I should have said this in the beginning, while 99% of the co-op prop leases will identify where the obligations lie, you should always check as it relates to your co-op, because there can be those nuances. I've seen some strange things over the years where things that in 1,000 buildings are consistent and one building has some nuance, which is completely different. Sometimes that often happens with windows, in the co-op, it's presumed that, as an example, the co-op is going to be responsible for maintaining and replacing the windows, but I've seen a couple variations of that where it's not the case. So just be careful. But yes, to answer the original question simply, as long as the co-op continues to maintain a component of the building that they are obligated to maintain under the prop lease, that will forever be their responsibility.
Thank you. And then these could be for either one of you. Please address allowing an e-scooter in the building from someone who states they need it for disability.
So I think, when you start getting into disability laws, it would come down to whether it's a reasonable accommodation or not. And I think it's, you have to weigh the safety. If there's a safety concern, and there's a prohibition in the building for e-scooters or for e-bikes or something, that's one consideration. But it is, can it be stored safely? And if it can, then I think you'd have to make a reasonable accommodation. So I think you'd have, it would be fact specific, but I think it'd be tough to keep someone, with an e-scooter out, depending on how dependent they are on it, and things of that nature. It'd be fact specific, but you definitely have to be aware of the discrimination laws there.
So going back to a recommendation, seek legal review before denying any requests, for sure. How do you enforce a court order that requires a shareholder in a co-op to dehoard if the hoarder will not do so and just ignores the court order?
So in my experience, I try to, for hoarding cases, I try to go to Supreme Court instead of housing court, just because I think that you'll get a better result from the judges there. But we've gotten court orders that said that we can go ahead and just do the work. We've actually done that, where we actually relocated the shareholder. We put them in a hotel, and the apartment was more or less gutted, and we bought replacement furniture for the shareholders, an elderly person on a limited income, and they couldn't really take care of themselves. And I think we also got adult protective services involved. So in cases like that, it can be a long process, but it's certainly, you can get the result that is better for the shareholder and for the building to make it safe. It just, sometimes you have to get the court involved, and it might take going to court more than once to get the court to see that this person is not compliant.
Thank you. This has been really great. Thank you both. Really appreciate your time today, Stephen and Hanley. We've been able to answer questions throughout. We will circulate information. Should anyone want to, please reach out to any one of us. We'd be happy to circulate this webinar as well, and it will live on our website. So have a great day, and thank you so much. Have a wonderful one. Bye-bye.
Thank you. Bye.